but we do have pretty much everybody.
Okay, we can begin. It's time. So, good evening, good morning, and good afternoon to all of you. Thanks for coming back after 12 hours. Good to see you all. We have two important things on our
Stavros, you're muted. You're muted.
Yes, I am muted. So let me start again. Good evening, good morning, good afternoon to all. It's nice to see you after 12 hours. We have two items on our agenda today, tax planning and the Loan Association post-implementation review. The tax planning is, of course, the presentation of the working group, and Jens is there with a nice background, as Andy has noted. Nice shadows in the background. So I would like to start with that. Jens, please take the floor.
Thank you, Stavros. Hello, everyone, and I hope that the shadows will be more transparent or more enlightened after that presentation. I will try my very best. So the working group, you know, is comprised by Sanjeev, Laurie, Andrew, and me, and we are very, very good supported by Carla. Next slide, please. What is the objective of this session today? The first and most important item is that you receive the final report and our recommendation of that tax working group. And we have received some comments from board members in advance. So thank you very much for that. And I think we will have enough time to consider the project proposal, our second item for today, and we will see how we will proceed with this. So we have all the time to discuss the proposal, and if necessary, we will make some further tweaks to this project proposal. But first, the feedback and the final presentation for our report. Next slide, please. I will very briefly make a recap of the recommendations and the report, discuss the options, and will try to explain and make transparent the rationale for the working group recommendations, and then talk about the project proposal, objectives, focus, and scopes, and try to describe some items which we think are relevant for this project proposal. So a principle-based approach, the stakeholder consultation, and the alignment with the public interest framework. And last but not least, we are proposing a quite ambitious project timeline. So on the next slide, a short recap from the June 2021 meeting, where we presented to you the working group's preliminary report. We tried to explain and we discussed on the one side the global developments, so that there is a development and a further discussion on global tax revenue, on the recovering from post-COVID situation. And we have witnessed in these few months many discussions about international policy initiatives, G20, OECD. And on the other side, we see that there are fragmented frameworks. We see that in many jurisdictions, or in some jurisdictions, it would be proper to state, there are many initiatives and proper frameworks and specific regulation on taxation services and tax planning services. But on global level, there is the perception that there is a fragmented framework and not enough guidance or even a hole in the system. We had further stakeholder engagement in this 3 months. We had a CAG meeting, I will report separately, an NSS meeting we had with some members of GPPC, further consultations, and with institutes. And we see the public expectations from different angles, from scandals, as we know, an ECG discussion, some stakeholders questions whether there is a connectivity between our projects and ECG developments. I would put it like this: you can make a technical build a technical bridge, because if you look at some of the frameworks, ECG frameworks, there's also a chapter on sustainable taxation, not on a country level, but on an entity level, so that companies should make their tax policies transparent, and by that become a part of the focus of the work of an accountant. So there is a connectivity in discussions, and we have what I mentioned earlier, the post-COVID-19 discussions on a sustainable economy. So these are the broad issues we also discussed at working group level. And on the next slide, you know this slide very well, and I won't go too deep into these options, but only to draw the picture that we have presented 3 different possibilities of reacting, and from option A, to do something in the code and to develop overarching material in the code, and option B, to develop very specific material under one or more fundamental principles, and option C, to develop material outside the code. And we have heard in this board meeting something on NAM and their and the role of NAM. The working group has tried to
We can't hear you.
Yes, you muted.
I saw the sign, sorry. And the working group has tried to understand the feedback and to balance the feedback from stakeholders. And we see that there is a role for IESBA as a standard setter. And there is a need of a discussion whether there is a hole in the code. And I see some parallel to the technology discussions we have had yesterday, and following very carefully Rich's presentation, there is, from the perspective of the working group, the need to, for example, expand guidance to acknowledge tax planning issues. And we have also heard something about the factor of complexity, and you have witnessed in previous discussions with the working group, or in the working group, and our view that there is a similarity in the complexity issue which we have detected in this space here. So there is a public interest importance. There is the role of the IESBA as a standard setting board, and there is a difference between non-authoritative guidance as NAM and to have something, application material, and perhaps, if necessary, also a tweak of requirements. We can't prejudge this now. That is the work for the task force, but to have authoritative guidance in a broader sense, where on the one side, the practitioner, but also the public is recognizing that the profession is taking, that the code is relevant also in this space. So what the working group is recommending is not a revolution, but to have a proper mirroring of the tax planning issue in the code. And talking about unifying frameworks, I think it's perhaps necessary to make clear, and you have read our final report, we are not trying to define terms which have to be defined by the local jurisdictions. We had a broad discussion on aggressive, acceptable, unacceptable terminology. I think the working group has come to a preliminary view, and we have articulated it in our report, but the task force will have to discuss it further. But my personal opinion is that there is no need on global level to define finally what is acceptable and not acceptable, because it would be totally against the structure of tax regimes, because it's a national or regional issue where those jurisdictions who are responsible for defining it have to be clear. And if there is a framework, as I know that it exists in some jurisdictions where very nitty-gritty rules are there, which percentage is accepted and which way of transparency towards a tax authority is the right way, this is the way how to behave and how to handle with acceptable or unacceptable. That might differ from other jurisdictions, but I just want to make this as an example clear that IESBA is not able to define on a global level. The same is true for what is NOCLA and what is against laws and regulation. It's just a framework which mirrors these national jurisdictions and make for that's I think important, make the accountant aware of differences, especially in cross-border transactions. So that is the rationale for the working group's recommendation. And on the next slide, I would like to give you a report back from the CAG meeting, which we had last week. So I can report that we had an immense support for the project, and the speakers and members of CAG were pleased that we are moving now to a project proposal. So the timing was appreciated. And there was a strong encouragement for a principle-based approach and to leverage off work of bodies such as OECD and European Commission. And most are supportive of the preferred option or the recommendation by the working group for option A. There was advice for an impact assessment if the task force is proposing further revisions to the code. The representatives were concerned with the matter of terminology I just mentioned. For example, the issue of acceptable or unacceptable tax planning. For some of you, you have perhaps seen, because it was also mentioned in the CAG meeting, there is a consultation paper out of tax advisors in Europe who are handling or questioning the same issue of defining or not defining. And we will have, just for your information, because it was not to make earlier next week, an outreach activity to understand their approach. But we are very aware of the fear of, or the concerns of some stakeholders not to overrule very specific regulation in certain jurisdictions on acceptable, aggressive, or whatever terminology is used. So we are aware of this specific issue, but that's why the proposal is to go further into that, and the task force will consider this. Some representatives queried if the task force, the future task force, would consider the transnational nature of tax planning and the different types of entities, whether there's a need of make a differentiation between PIEs and non-PIEs. We have taken that on board, but the working group has had not yet the possibility to consider. And there was a huge emphasis on the linkage to the concept of ECG, especially from those jurisdictions where GRI standards, which includes tax sustainability reporting, are a preferred or a significant used framework. So that is the feedback from CAG, and I will pause here. Perhaps Galen, if you want to add something.
I'm sorry, gents, but I lost the last 5 minutes. My headphone ran out of gas with the charging. So I'm looking at the bullets here. I think there was a great deal of support from the CAG, which I believe that you had presented there and is summarized in the bullets. I do recall a lot of discussion about the linkage to the ESG concept and some questions as to whether that was a direct or indirect linkage, and maybe that could be strengthened a bit in the presentation. But I don't know in terms of, I mean, that was in the discussion memorandum that we received. And I don't know that that's a central part of your presentation. So I'll back off on that.
Thank you. I think that was specifically raised, the ECG connectivity, because of the extant discussion on European level, where there is a discussion on standards on reporting and the question of including taxation issues there. Thank you, Galen. On the next slide, the condensed recommendation by the working group is that the board undertake a project to develop enhancements to the code to address ethical consolidation when public accountant in business and public accountant in public practice provide tax planning services. On the next slide, I would like to summarize and explain a little bit the project proposal, and perhaps we will have after my presentation the time to receive also specific feedback on the project proposal, but we are trying to summarize the objectives, focus, and scope. We want to have a principle-based approach. A framework means in this context, and that was a concern which was raised in some of the pre-board information I received. What does it mean? It should not mean to make something different to the extant framework we have in the code, but it should be a framework. The framework should be clear for this specific situation. So it's an application of the extant framework in this context of tax planning. We described in the project proposal the approach, and then the consultation, and the public interest framework alignment, and the proposed timeline. On the next slide, you see summary of the objective is to develop a principle-based framework to guide PA's conduct when providing tax planning and related services to employing organizations and clients. So it is based on the conceptual framework and the fundamental principles. And the question is whether there is the need for further application material and perhaps requirements. The focus is on the ethical conduct, and it's very, very important to mention that IESBA, that's our view, will not analyze merits of any particular tax positions, tax fee schemes, or tax regimes. So we fully agree that taxation, and that is a limitation of the project, is a national issue, is an issue of sovereignty. So if there are jurisdictions who have already ethical tax standards for tax planning, that's great. That's the starting point in that jurisdiction. But we try to find commonalities and to find a framework for the global level and for jurisdictions where there is no such framework. The scope is to look at part 2, part 3, and to look also at enhancements to part 1. And I have heard some concerns concerning part 1, because we at that stage in the discussions we had during the last few days, we have a many enhancement in part 1, and there was a little bit of caution not to go too many times to that, but we can't exclude it from the beginning to have also enhancement in part 1, especially as we have heard from some stakeholders or many stakeholders that the role and mindset project should be a little bit an example how to approach situations we will focus in a potential task force. So on the next slide, there is some idea of a principle-based framework approach. So the broad objective is to guide professional accountants in making ethical judgments and decisions when providing tax planning services. And that includes that that there is guidance to assist PAs to make an assessment, to identify threats in a situation where there is a possibility of acceptable versus unacceptable tax planning. As I mentioned now several times, there is a need of cross-reference to jurisdictions, and I could not imagine a situation where the code will overrule clear regulation on national level, because that is something some members of the board articulated towards me. So there is the caution I mentioned earlier of national sovereignty, jurisdictional variations, etc. It is about the circumstances, facts and circumstances where there might be undue pressure or other threats. The recognition that an inducement might be offered, and as you have read the project proposal, there is also the notion of intent. So that one factor could be the intent issue or the reasonable and informed third party test, how some behaviors are perceived by a third party. We are not trying to invent new tests here. That's my reading of the proposal, but to look at other parts of the code to see how these solutions are also appropriate in a tax planning situation. So another aspect is to provide guidance on when and to whom to communicate, management, those charged with governance, but also tell the client which risk he's facing to go for this or that situation. So it's about transparency also towards the client. And I think it's very important, the objective of the project is not only to react to public expectations, but also to protect the professional accountant in specific situation, how he should or she should deal and make issues transparent towards the client, internally, externally. I just mentioned the consultation issue, which is the next column, and to address also the transparency issues on the one side and balance this against PA's duty of confidentiality under the code. And last but not least, there is still perhaps some reference need for documentation expectations. On the next slide, there is a broad range and picture of potential consultation the task force will have to consider. So continuing exchange with the CAG, with regulators, mainly in the G20 countries, but not exclusively. So that is just a notion to say in many jurisdictions, and to have also consultations, constant consultations with the MSS, with IFAC and in PAB and SMP advisory groups. And just to highlight here, we are all very conscious of the IFAC publications from 2019, which will be one of the role models or starting points for discussions how especially concerning application material, which might be an example, how to add something then to the code. You have witnessed the further development with OECD and the constant exchange with OECD, and that would be very important to continue. Investors, preparers, and governance communities, professional accounting organizations, accountancy firms, but also law firms and the legal profession, because some concerns raised during our working group phase and also articulated in the pre-board comments is that it's important that also the legal profession is somehow included in these discussions, although we are not able to set standards for the legal profession, but to understand the argument and the concerns we have heard, that there is also the danger that where the accountants are regulating something, the legal profession could have other views, and that would be a bad outcome if this would have impact on the competition between different professions. So we want to understand, and that's a proposal to understand the positions of the legal profession and to understand where and why a so-called legal privilege is used, or as some have put it, is perhaps also misused in this tax planning and arrangements and structuring situation. So that is part of the stakeholder consultation program. On the next slide, there is the alignment with the public interest framework. What are the objectives? The key outcomes to be sought is to promote consistent behaviors and practices in the area of tax planning and related services, to raise awareness about the risks to employing organizations, clients, and the profession, to promote by that fairness, accountability, transparency. Just one remark on that tax morality issue, which it was also raised, to be crystal clear, it's not in the scope of this project to give further discussion to tax morality. We know that in the public there is a discussion, an ongoing discussion, but that would be not the objective of that project. It is clear that we have to consider and to see that this discussion is there, but the morality part is not possible to solve on a global level. And that's why this approach we are proposing would have fair response to the overall discussion on fairness, accountability, and transparency. The scope is to have a broad view and to find a scalable solution which is appropriate for PABs, PAPPs, to small organizations, large global networks, and organizations and corporations. It is also for individual taxpayer clients, as for corporates. Who are the beneficiaries for whom we are trying to develop standards? For investors, taxpayers, NSS, tax authorities, preparers, those charged with governance, and policymakers, and the global accountancy profession. As this is an issue of public interest, there is also the society at large and societal organization which probably will react to this project. The timeline on the next slide. The ambition is to get approval to this project in this September board meeting, and then form a task force which then will update the board in December on the first activities, and have then first issue discussion in March, discussion in the CAG and on board level, and to have further discussions in June, and to prepare first read of proposals in September. So this would be the plan, to have then an exposure draft in December next year. And if we are looking forward to a final pronouncement, then this would be in 2023, to have a high-level update, a full review of exposure draft responses, and then in December 2023 to have a final pronouncement. Next slide, please. So now I would like to invite you to discuss first, are there any other substantive matters that should be included or further discussed in the project proposal? And are there any other general or specific comments relating to the final report or the project proposal? Thank you, Stavros. That is my presentation, and now we can switch over to a discussion.
Thank you very much, Jens. Yes, we can switch to the discussion. I would like to invite members to offer their comments. And as I do for every topic, I would like to invite members to be as brief and succinct as possible, so that we not only can be on time in our work, but also we can have clarity on what needs to be considered. So let me open up the floor for comments.
Okay, the floor is open. So any members has any comments, please raise your hand in Zoom.
Si Sung Nam.
Yes, thank you. I think your presentation is very informative and forward-looking. I have one question to have a concrete idea. You said that the project scope will be limited to revision part 2 and 3, and also possibly on part A. So there will be no change or revision to Part 4A, which is auditor's independence as a result of this project in the future. Is my understanding correct?
Okay, let me collect questions rather than Jens addressing each one. So I see Caroline Lee. Caroline? Caroline? Well,
Since your computer will not let you speak, Caroline, you're going to have to use sign language.
let's go on to Sadia and we'll come back to Caroline. Sadia?
Thank you, Stavros. So I have passed on comments to Jens offline, but I thought I'll just mention the ones that are potent. So the first thing is that with the presentation, I'm comfortable with the direction of the project and the project proposal. But when we go to the detail of the project proposal, I wondered if we could highlight the significant items from the items that will have cross-reference and emphasis on areas of the code that are already in there. So I'm really looking forward to seeing what's the requirements of the section that will lead to change in behavior of the future. So as we consider this framework and the public interest that is related to it, I would like to see those items stand out. I was a bit concerned that in paragraph 15, after the first one, there was a lot of the word of the use guidance and considerations of which spoke to more application material. And I hope that the future task force will consider requirements as well to make sure that we're getting the right tone of the project. My second item is on part 1 of the code. And I know we've categorized it as amendments to part 2, part 3, and then considerations of part 1. But I foresee that part 1 is going to give rise to things that needs to be considered at the project proposal level. And that is coordination with the technology working group. Because as we start this project, the technology working group would have driven already a process, and we might need to meet at a certain point to see which paragraphs overlap. And I've raised this yesterday. I'm just a little bit concerned about paragraphs constantly changing. So if there's an approach that the future task force can create a new paragraph rather than going and tweaking old paragraphs, I would really hope that they follow that pattern to ensure that the code is evolving and not reworked all the time. Thank you.
Thank you, Sadia. Let me also take Caroline's comment now.
Thanks, Stavros. Sorry. Ian, thanks very much for the presentation and the report that the task force, the working group for the report that was done. The report was very balanced and thorough. One key area of concern I have is, we recognize that there's difficulty in defining, given that tax is very much a jurisdictional issue, and the challenge I have is that within the project proposal, there is a statement that says that at a practical level, we should provide guidance to assist a PA in identifying what might be deemed acceptable or unacceptable tax planning behavior. And I think if we, the use of terms acceptable and unacceptable then makes it, brings us back to definitions again. And I would like to suggest that the working group considers focusing on really what might be deemed to be appropriate professional behavior in the area of tax planning, and that will then encompass what's in accordance with our fundamental principles. So thank you.
Thank you, Caroline. So Jens, let me stop here and see if you have remarks on the 3 comments you have heard.
Yes, thank you, Stavros. Very brief and clear, Sung Nam. No, we have no intention, and it's not the scope of the project to look at independence provisions, because the independence provisions, we are looking here to a tax service provided by an accountant, not in the context of audit, because that is part of the, or was part of the NAS project, and it's not intended to reopen this project indirectly by the tax planning. We have addressed this planning issue in a new requirement, R604 point, I think 4, I'm not sure whether it is, but we have now a clear statement on tax planning in the context of NAS, and there is no intention to make something here in this project. Sadia, thank you very much for your remarks and the journal support. It is not intended to limit the scope of the project to application material. So that is up to the task force to see and to look at the extant code and see where enhancements are necessary. In the project proposal, we are describing some possibilities how to do this, and application material is one of the possibilities. And by that, we wanted to also include or mirror existent guidance materials, because we were asked whether we should do non-authoritative material, and we wanted to show that some of that, what people are expecting perhaps as non-authoritative material, would be better positioned in the code. But it's not a limitation here to application material. And yes, thank you for this comment. There is that you highlighted the need of coordination with technology, and I think that is something we should include in this project proposal. And Caroline, thank you for your remark, and also a possible solution you mentioned to avoid acceptable, unacceptable as a term. And I think that is something the task force should consider, whether it's possible to get the scene right by using the extant in the code existing terminology to describe this gray zone. By using acceptable, unacceptable, we just wanted to describe generically a situation where the professional accountant said, no, we are not in no class, but we are not also in the situation where everything is crystal clear. We are in between. So perhaps it is a solution, as you are proposing, to just describe this appropriate professional behavior in a situation where the judgment over tax planning services is in question. But I think that is something task force should consider, whether to develop new terminology or generic terminology, which is not necessary to be defined. I think that is an important discussion. Thank you.
Jens, we have Lisbeth.
Thank you. Yeah, first of all, I have a couple of thoughts that I want to share. But first of all, I want to congratulate this working group with a very extensive report at the start of, or in front of the project proposal in the agenda paper. It's very clear, it's very detailed, it's very informative. Good job done. Then moving on to the actual description of the project proposal itself. Having listened to this presentation, I am less concerned than what the project proposal is actually trying to describe as what you're going to be doing and what you're not going to be doing. I fully agree with the fact that there should be some material, whatever it is, an R or application material. Leave that up to the task force to figure that out. But to have something like that in the code that will give guidance to PAs on how to behave ethically when providing tax services to their clients or within their employing organizations. And I envision that a little bit in line to these principles that have been clearly described in that document that IFAC issued at the time. That's how I envision this project proposal should tackle this very difficult project. I am, however, concerned with how the proposal that you just went through in the presentation is actually expressed in the project proposal, because what is written here, especially in that section and at the practical level, goes much further than what you have been describing so far, Jens. And as I mentioned to you before, I'm particularly very, very, very concerned about the second bullet under number 1. So apply a judgment akin to an intent test, which is then aligned to the inducement approach that is currently being used within the code. Because I think if you go that route, you're gonna, well, it's gonna be a very slippery slope, to be honest, and you might create lots of unintended consequences with applying this approach. The main reason is there is no intention to define acceptable, unacceptable tax work. And that is good, because everyone else have tried it. Nobody has been able to come up with that definition. But nevertheless, if you want to apply what's in that second bullet, you will need to have a framework against which you can judge whether it's acceptable or not acceptable. And I've been thinking about lots of scenarios where I can see how this could easily go wrong. The black and white situations, yeah, you might be able to get there. But in the gray zone, I think this is going to create a lot of concern and eventually might lead to a situation where clients or employing organizations are going to say, well, you're actually not helping me here. So I will go to my neighbor, the lawyer, who can do whatever they think is right because of that legal privilege. So that's my general concern with this project proposal. So in order to be able to vote on it, I do think it's important that the language in there gets more aligned to what you just have been proposing or presenting earlier on your slides.
Thank you. Galen, you're next.
Hello, I think you called my name. I agree with much of what Elizabeth just articulated. And in particular, in looking at the report in the background section, just as example, there's under paragraph 2A, there's a sentence in there that says the project aims to ensure that the international tax rules do not facilitate shifting corporate profits away from where the actual economic activity and value creation occurs. Well, I don't know how you do that, because the board doesn't establish international tax rules. You know, so that is just sort of a stark example, I think, of how difficult this project will be in terms of sort of a narrow path of providing that ethical guidance to PAs that don't stray off of that path and into the area of trying to set tax policy or enforce tax policy. So that's one of the concerns I had. And yes, maybe you could just, the notion of pi versus non-pi did come up, I think, during the CAG meeting, and I frankly, I don't see any principal difference about whether it relates to a pi or not. It seemed like the principles would be the same, but maybe the risk is greater in the pie area. But I'd be interested in your thoughts on that. Thank you.
Thank you, Galen. Ken, do we have any other comment point, or should I revert to Jens?
Yeah, Galen, if you don't mind putting your hand down and return it over to you, Carlos.
Okay. Jens?
Thank you. Yeah, thank you for also these further comments. Elizabeth, you have mentioned the intent test, the inducement issue. This is something the working group has discussed, and it was something I think we received as an input from the board. With this notion of inducement, we just wanted to show the variety of possibilities how to approach the issue, but we didn't want to say that this is the approach which is the solution of the problem. And but I think we can look at the wording and make it clear that we are not trying to develop or prejudge an approach for the task force. And yes, your concerns concerning the legal privilege and the legal profession is something we have taken on board and will also highlight in the similar to what I said, that we will try to get an understanding how the law profession, the legal profession, is dealing with tax planning situations. Galen, I think the wording issue we will take on board and see how we can make clearer pronunciation in the project proposal. The pie non-pie issue, my personal view is I would agree with your description that there is no principled difference between pie and non-pies, but as you mentioned, big multinational corporates, which frequently are pies, are more in the spectrum or in the visibility and the public discussion, and by that, for the PA, it is even more important to understand the effects of his tax advice also to this public perception and discussion. So it may have impact on the evaluation and the public response to certain developments. But I think that is something that the task force should consider.
Thank you.
Mike Ashley.
Mike.
Thanks. I'm very supportive of trying to do something in this area, although I don't underestimate the difficulties you're likely to encounter going forward. The one thing I would say, just listening to that discussion about pie, non-pie, from a public perception perspective, certainly in the UK, some of the more egregious examples and things which have inflamed public opinion have been tax avoidance by individuals, not by companies at all. So just bear that in mind when you start talking about that, because yes, people don't like it when large companies do things, but they don't like it when high profile individuals do things either.
Thank you, Mike. Vanya.
Vanya.
Thank you, and thank you, Jens, for your presentations and for the comments that you are making to the questions of the board members. I'm very supportive of this project. It's a very well elaborated plan that you have, but it is a very sensitive zone, and of course every jurisdiction will be aware of that and worried that you want to step in what is their sovereign right to establish taxes and so far. So I advise you to have a very good communication team with you in order to make sure that everyone knows that what we are dealing with is the ethical side of that.
Thank you.
take your hand down. Are there any other comments from board members? Richard Kim.
Rich.
Yes, thank you. And Jens, thank you, and to the task force for taking on this very difficult and challenging topic. I guess I have a number of observations that first of all, I'd like to comment on this pi versus non-pi. I cannot understand how in sections 2 and 3, or even in section 1 of the code, there could be any differentiation between pi and non-pi. That concept only seems to apply when we get to part 4 of the code, and I think it would be inappropriate to suggest there are different levels of ethical standards. And in fact, I understand in a tax practitioner standpoint that some of the areas where there may be more of the challenging type things going on do involve non-PIs, even though the magnitude of the taxation involved for PIs gets more publicity. I have some very practical comments, but then I'm going to want to cover an overall one. I do not understand, and maybe this builds off what I just said, how in the paragraph 11 you would make this scalable. It strikes me that you need to have the same ethics views one way or the other. I also don't understand some of the points like communication with those charged with governance. We're talking about ethical conduct here, and we're talking about providing tax services across the board. So I just don't think that's practical in terms of how tax practitioners in a company, like tax directors, I don't know how a PA in business would make that happen. And I don't know what would be, my experience would tell me that there's very rare a case where a PAI in practice or in business would be bringing tax planning matters before those charged with governance, which is defined in most cases as boards of directors or equivalents. Because again, we're not talking about auditor independence here. We're talking about services to entities across the board, and we've dealt with the independence issue already in NAS. And so it would strike me that this is targeted at situations where the professional accountant in practice has no independence related responsibilities or restrictions at all. And I just don't think that communication is practical. I'm also note that we're not going to deal with the morality issue according to this, but we very quickly seem to say right away we are going to deal with it with acceptable and unacceptable, and reference to gray area and to social or societal views. I'm also struggling with transparency when one is in a role that may be more advocacy in nature in terms of the activity going on, particularly if I'm a PAI in business. But I think more importantly, stepping back from all that, is noted in the report. There are differences in tax regimes around jurisdictionally, many of which were done, differences are for very specific reasons to develop and enhance the economic conditions in a country and attract business, employment, and therefore revenues. And it seems to me that there are many kinds of situations where one jurisdiction considers a matter in one manner and another in a different. So there can be instruments that are debt in one country and equity in another. There are instruments, or there are structures that are considered corporations in one country and are disregarded or passed through in another. There are countries who have put super deductions in place to enhance investment. And there are very simply the point that jurisdictions have decided to have different rates, some of which are quite disparate, as the OECD, some of the OECD materials. And I think that we're never going to, if you're going to hold the professional accountant, the tax practitioner at a company, or their external professional accounting advisors responsible for the fact that jurisdiction B does not like that the outcome of a transaction because jurisdiction A had a different regime, that's going to cause the professional accountants, that's going to be not manageable from a code's perspective. But I think we also have to understand, how do you plan to do this in a way, and I think this did come out in some prior discussions at the CAG, that the practitioner is not, the professional accountant is not now subject to regulatory scrutiny or enforcement simply because they followed a transaction that was legal in the country they did it, and somebody else doesn't like it. And that gets to my overall point, is I think a lot of this has to do with people who don't like the outcome from the jurisdictional standpoint they sit in. Finally, there are standards throughout the G20 and also at the national standard setting level that already govern tax practice. I think it's pretty well established in this day and age that there are you must have business purpose and economic substance to do these transactions. And I would be concerned that we create something that either overrides things that national standard setters put in place, or go beyond what might be required in those various regimes. Because I think that there's a risk here that we put the professional accountants in a challenging place, and that might result in, on the spectrum of who advises on taxes, pushing this into corners of it that are unregulated or not subject to frameworks like this, which is not probably, in my mind, in the interest of all. So I'll appreciate the time to speak, but more importantly, I want to thank you again for this is very challenging, and I appreciate the efforts that the working group has put in.
Thank you, Rich.
I see no other hands raised at the moment, so I'll turn it over to you, Jens.
Yes, thank you. I think the pi non-pi issue, Mike, you raised with the individuals or very rich individuals, that is one of the reasons we see no principal differentiation between pi and non-pi. And as Rich as you have pointed out, there's also conceptually probably no sense or need to do so. And because we are in part 2 or 3, for me, pi non-pi could be a factor, perhaps, or a circumstance where you are describing a situation, and perhaps some of the issues you mentioned, Rich, are a little bit driven. For example, those charged with governance issue is a very specific reaction from regulation in GRI. I think it's 205, or that's my remembrance, where there is, for example, the necessity that the company is giving a report on tax strategies, giving a report on tax policies in a certain company. And and that was just a situation, we talked with some global CFOs, with representatives of global company CFOs or tax directors, that there, and that is addressed to PABs, have internal rules on when and how even the tax director has directly report, etc., to the management board. We don't want to establish here a new regime, but we want to describe the situation in which a PA may be. And that's why we have taken also some factors or circumstances which are here mentioned. I understand fully your overall concern. The approach of the working group towards this issue is not, and perhaps this has to be a little bit more clarified, to be a standard setter which is overruling national laws and regulations. So it is the problem we detected or we described in our final report, that there are different regimes, that there are exactly what you're describing, Rich, different national interests, and the PA is in between. And if there is a clear anti-avoidance rule or transparency rule, how and why you have to do this in one jurisdiction, the code is, I think, is not able to say, even though its expressed view of a national jurisdiction is against the global view, or whatever you call it. It is more about the question how to act now in a situation where in one jurisdiction it is acceptable, in another it's not acceptable. It should be part, if it's a transnational issue, it should be part of an ethical assessment how to behave there, but not to overrule national regulations. I see the tension and the limitation here, but I think we have to especially as you mentioned, Rich, that there is a risk to put the professional accountant in a challenging situation. My perception is the professional accountant is nowadays in a very difficult and dangerous situation because he is not guided, or he's a little bit lost in this jurisdictional conflict. And what we want to try is to give some space for a proper approach there, not to overrule a national solution, but the cross-national solution can't be solved by one jurisdiction. And so we have to show the conflict and give guidance how to behave, because situations nowadays are that the professional accountant is in such situation seen as not acting or is acting in the right manner, and we have no proper tools or frameworks which are directly addressing this ethical conflict. So that would be my reaction. I see the problems and the dangers, and I think we see the cautions, but on the other side, the situation is as it is, and the professional accountant is acting there, and we should give him some support here. And Vanya, yes, it is a very sensitive zone here, and I think as we also listen to the discussion here, we always have to make sure that we are not someone who is going into the international tax planning arena. We are looking the ethical impacts on professional accountants in a national or international environment, and to make it right for the professional accountant, and to react to the articulated concerns by the public.
Thank you, Jens. Brian Friedrich.
Brian.
Thanks. And thanks, Jens, for a great presentation, and to your team also for the work that's been done on the project proposal. As many have said, it's very thorough, and I think well supported by the work that's been done in the past. I am very supportive of this, although admittedly challenging project. Again, I don't think I'm telling you anything new. It clearly, though, continues to be seen as a public interest priority and an area of exposure to our profession's reputation and therefore trust. I just wanted to pick up on a previous point as well. I really don't see this about ever being about a like or not like decision within a jurisdiction, but rather squarely about ethical versus unethical. And so to the extent that my understanding is that's where the task force is focused, which was my read of the project proposal, it's then really the job of the task force to try finding a common understanding of that ethical versus unethical threshold and a framework of how this distinction is arrived at. And to me, all of that comes back to the professional values, and I know you don't want to go down values and morality, but we do have certain values and morality that I think are embedded or certainly implicit within the fundamental principles. So to the extent that that's happening, I think that's an entirely appropriate direction to go. Thanks.
Brian. Ian?
Thanks, Ken, and thanks, Jens and the working group for the paper they put together. I think it's very considered and quite measured in the way it's presented. And I agree with the comments that there's certainly a lot of issues here to be considered. But I guess I just want to say I'd back the working group to consider these as they have and as Jens has presented today, in a measured and considered way that considers the ethical conduct of PAs, and so I'm very supportive of this project. It is an important area, and I think we'll all benefit from having a project. Thanks very much.
Yaoshu?
Yeah.
Thank you, Ian. And I think that's as Ian has said, that the tax issue is more jurisdiction issue. So the task force may use more principle-based approach and the conceptual framework to give the pollution. And we know that that's the tax planning service, that's the PA, is not the only provider the service. So we needed to give the PAs more guidance to help them to deal with the issues they faced, especially during when they found that snow color occurred, and we can give them more guidance, not to give them more limitation. Thank you.
Yeah, sure. I'm not seeing any further hands raised at this point. So, okay. Well, I see a couple. Jens, I don't know if you want to take a couple more or you want to respond.
You can take some more.
We'll take some more. So maybe Stavros, I'll turn it over to you.
Well, please take Galen, and I will make a comment afterwards.
Thank you, Stavros. So it seems to me, Jens, at some point, one of the fundamental issues of a prospective task force is going to be there will be a threshold issue of whether a tax position that the PA has taken, if challenged by a tax authority, whether that position can be sustained either in court or whatever the process is in that particular jurisdiction. But it seems to me like that should be a lot of focus of the task force. Whether the PA has enough support for the positions that are being taken, whether they be a PIAB or a PAPP, I think those would be quite similar in terms of the ethics that would be expected to be followed. Thank you.
Stavros.
Yes. Well, Galen just stole some of my thunder because one of the points I wanted to make has been about complexity of tax law and uncertainty as to what is legal and what is not legal at the boundary. And I will not repeat what Galen said, but I agree very much that this is an area where items like what we have in role and mindset and items like trying to position the advice into the what would be likely for a tax authority to accept, what will be acceptable to a tax authority, are important elements in what we do. Because there is uncertainty and complexity at the boundary between legal and illegal, also at the boundary between acceptable and non-acceptable. This varies across jurisdictions, and this can become quite a difficult issue when you have, of course, cross-national, cross-boundary transactions. My second point is that I believe that we should start. First of all, I want to congratulate the working group for their diligence and their prudence and the caution, because this is indeed a complicated project. This is indeed an area where we should not make the mistake of going into the boundary of tax policy. The accountant is not going to be making tax policy, should not. Therefore, I believe we should not prejudge before work starts as to whether this is going to be guidance, this is going to be requirements, this is going to be related to role and mindset, and so forth. So I think that as the working group has been very open-minded, so should the task force be, because this is the way to proceed. I also, my third point is that I very much agree with something that Jens said, and in a sense goes back to what Mike was saying, namely that this is not only about corporate taxes, this can be also about taxes of very wealthy individuals. And therefore, this issue of pie, non-pie, I think may not be as relevant as we think. And finally, I have this simple test that I would like to suggest, namely that whatever we come up with holds equally well for a tax advisor in a high tax jurisdiction and for a tax advisor in a tax paradise, because that is a very simple way of thinking about offering ethical advice and not advice about tax policy. So,
Stavros, do you have any further comments, Stavros?
No, I'm just finished.
Thank you. Thank you. If you would take your hand down, and I'll turn it over to Jens at this point.
I will take my hand down.
Thank you. I just want to thank you to all your comments, which are very helpful. And I just want to mirror some of the mentioned issues. Thank you, Gail, for this uncertainty issue. I think this is something a task force will have to discuss, whether there are two situations. You have a pure national tax situation and you have a cross-border situation. I think in the one situation, you have only one jurisdiction to consider, and whether you have there very specific regulation, yes or no, how to behave, and to whom you have to consult, or to whom you have to be transparent, tax authorities, etc. But if you have a cross-border situation, it's more challenging, and probably there will be no specific guidance, because these two jurisdictions will perhaps have different frameworks. And so the awareness of the difference is one key point. And the next point, how to behave in conflicting situations between jurisdictions. So I think this test you mentioned is very important. And thank you, Stavros, also for this very simple test you notioned it, that it should be appropriate. And perhaps that is the better notion than scalable. Should be appropriate in all this type of situations. A tax advisor in a high tax country and in tax paradise, but also giving advice to a small company or an individual, or giving it to a big global corporate. I think that's my reaction, and probably the working group should consider these also very specific comments we received also in advance of this session. And that would be my proposal, that we tweak a little bit the proposal, and reflecting the comments we received today and come with a revision to the last day of the board. I think it's next week or the week after.
Well, Jens, thank you very much for that. And again, many thanks for the board's comments. I think it is appropriate that the working group take another look and see if you can come up with revisions, because the discussion today was very rich. Before I close this session, I would like to ask our PIOB observer, Robert, to come in with his remarks on this project. Robert.
Thank you, Chair, and thank you, Jens, for the presentation, and to the task force for the care being taken, as the Chair noted. And I'd just like to reiterate the PIOB's support for this project. I don't need to say too much, but could I just make a couple of points personally first, just as a lawyer, personal observation, that I fully support what's being talked about in relation to outreach with the legal profession. The negative impacts of legal privilege on tax have been well known for a long time across the two professions, and the interplay between the two professions, and the whole issue that's just been discussed about legal or not, and transnational challenges are all really important. But I think the other point, just as, and I'd say this as a lawyer, might be helpful just to provide some encouragement for the legal profession also to develop its response to these issues which are being raised globally. There isn't a global code of ethics for lawyers, but it's certainly in the public interest that the profession develops its own response. So the more encouragement that can be done, given for that during the outreach, I would personally be very comfortable with, but of course that's a personal observation. From the PIOB perspective, the project looks well scoped, and it'll be interesting to see what enhancements can be made before the final day of the meeting. There's clearly good regard to the public interest factors. The multi-level approach of the general level and the practical guidance looks very strong. And can I support the intention to use the public interest framework, Jens, in developing the proposals? We're starting to test drive the framework with both standard setting boards now, and this would be a really good topic to do so. And I'm sure that going forward, the PIOB, both at the board level and at the staff level, will be happy to discuss that aspect as it proceeds. I was just going to say something about inducements, the reference to inducements, and was just intending to comment that that it's not necessarily enough on its own because of the more personal impacts of inducements to set a high enough bar. But I think that point has been covered in the discussion, so that's fine. And as has the link to the ESG principles, and it's very good to see the CAG support for this, and indeed, Galen, for the project as a whole. Can I just say something about the timeline, because this is something the PIOB has been encouraging, or perhaps awaiting is the better word. You'll recall that both my CAG observer colleague and I have earlier made references to the need for there to be a timeline set once the project has been established. So that's now been done. It's the comments about this are certainly not to underestimate the difficulty of the challenge, or indeed, Stavros, I think you just talked about open-mindedness, and that's important as well as the extent of the outreach that's going to be needed. But it will be a 4-year project overall, and we're just halfway through it now. So perhaps, Chair, all that I can do at this point is just to restate the need for the project to be proceeded as a priority project, and perhaps just to recommend that the board and the planning committee might keep this under review. And I'm sure the PIOB will be happy to keep this under discussion with you and the technical director as things develop going along. So I just want to convey again a very positive response from the PIOB to the project, and we'll look forward to observing how it develops from here. Thank you.
Thank you very much, Robert. And let me simply make the comment about the timeline and the need to give priority to this. The planning committee and the board clearly think this is a high priority project, but I always have a caveat with that. And I always have a caveat with the PIOB's, shall I call it, impatience for results coming out quickly, with which I agree. I think we all want that too, but we should not sacrifice caution and wisdom in the course, especially of a project like this, and especially at a time when international tax policy is really having a very high profile in discussions, and we must be sensitive to that as well. So, of course, we agree, but I know that the PIOB too realizes that we have to be wise and diligent. So I just wanted to say that because
and thank you for saying it, Stavros, and certainly agree. And I'll report this back to the board, and I'm sure that the board will be happy to discuss it with you when we next meet with you. Thank you.
We will be discussing this project anyway at the next PIOB meeting. So thank you very much, Robert, and thank you very much, Jens, and thank you very much, task force and staff. Carla has worked very hard at this, I know. We received a lot of good comment. It looks like we'll have to make time on September 27th, right, Ken?
That's correct. Yeah, we'll bring the revised project proposal to the board first thing on the agenda for September 27th.
Okay.
Yeah.
And I will defer the determination of the task force until that time.
Correct.
We have to do that as well. So thank you very much, Jens. Thank you very much, all. We'll go on a 15-minute break, and we'll come back to our next item, which is long association post-implementation review. So 15 minutes, please. It's we're coming back at 45 minutes past the hour.
Yeah.
Okay. Thank you all. Hello, Richard. Welcome. Good to see you.
Morning, Stavros. Yep, good to see you too.
We are ready. We'll go in about a minute.
No problem. Thank you.
Hello, Richard, from me too. Nice to see you.
Good to see you, Robert, and enjoyed your comments.
Well, thank you. I did make a personal observation about the tax matter just a few minutes ago. I'm not sure if you were on the line at that time, but from a personal perspective, I added my support to having some outreach with the profession on the tax issue. It's not really a good idea to just address it with just one of the two professions, is it?
No, I heard that. Well, I listened to the last presentation, the session. I've actually been on all of them, but no, I absolutely agree with the point you make, and it's actually rather important from a different point of view, which is that a legitimate anxiety from the profession, the accounting profession's point of view, is that if they are if they're subject to a regime which is different to their primary competitor, you've got an uncomfortable anti-competitive balance there that really shouldn't be there. And I know that's a view that the profession has held for some time. And actually, like you, I don't think that would be appropriate. And that's a balancing factor which I would hope in due course will be taken into account in the way in which the project team approaches the issue. It's a genuine issue.
Well, conversation between two eminent lawyers. I like that.
They do occasionally, Stavros. Every so often, lawyers do talk to each other.
Yes, okay. If I may change the subject, the turn now has come for the long association post-implementation review conversation. This is phase 1. And I'm very happy that Richard Fleck is back. He's going to be presenting this. He's chairing the working group on this. And as we all know, and the newer members will not, of course, remember, but Richard was chairing the task force for long association, which was one of our very important standards. So I'm very happy to welcome you back, Richard, and to give you the floor.
Thank you, Stavros. I'm conscious that you've all had some pretty challenging and subjects to discuss so far this week, and I thought I would introduce this with a light comment and point out that Long Association Post-Implementation Review stands, the acronym for that is LAPIR, and a lapia is a small, fuzzy, cuddly animal, and that is the nature of this project or working group project compared to the challenges you've been dealing with before. So with that slightly light introduction, let me thank and acknowledge the work of the working group, which comprises Kristen Windle, Sungnam, Sadia, excuse me, ably supported by Jeff. And we have a presentation for you. It's not a long presentation. And as the bulk of it is a report back and a comment or taking you through and describing the comments we've received in response to our questionnaire and the key issues that have arisen, before coming to 3 slides which summarize the working group's views and recommendations. I am, Stavros, going to go right through the presentation rather than break it up, because I don't think there's a logical place to pause. Next slide, please. So we're going to start by going through the background, and the first thing to emphasize is that the Long Association Post-Implementation Review has 2 phases, and the first phase, which is the one we're now dealing with, focuses on the provision that permitted an exemption to the 5-year cooling off period, colloquially known as the jurisdictional provision, because it's based on the situation where in a particular jurisdiction there's already a legislative or regulatory framework which is less demanding in terms of the cooling off period for engagement partners, and permitting compliance with that less restrictive regime for a period of time up until the effective date in December 2023. Phase 2 is intended to look at the much wider issues that arise from long association, including such things as mandatory firm rotation. And that's a project is, I think, scheduled for Q2 of 2023. Next slide, please. So since March, the most important thing we've done is to set out a questionnaire, which we shared with a number of different groups. We sought comments and responses by the end of May, and we received comments going on after that period, all of which we've taken into account. And as a result, we have some 30-odd responses, which I think we're just going to come to, 32 responses. And this is a summary of what we received. Now, there's an important point to make at this stage, and that is that we offered the respondents to the questionnaire anonymity. And so these comments are separated, split up by reference to their stakeholder group and their geographic area. You will see that there are 4 regulatory responses, monitoring group responses, 2 from independent standard setters, 1 from a public sector organization, and a large number, the largest number, from national standard setters and professional accountancy organizations, 17 from there, and 8 from the firms, including from the 4, the usual 4 global firms. There were quite a number that did not raise any issues, but some obviously did. And the next slide, I think, will take us to that. Now, just before going to the comments that were made, let me just summarize the relevant provisions. The starting point is paragraph 540.5. And the significance of this is that it prescribes that there should not be, nobody should hold positions as an engagement partner or an EQCR or a key audit partner for more than an aggregate of 7 years, and that after that there should be a cooling off period in accordance with other provisions. And the cooling off period was set at 5 years, with the jurisdictional provision, as I've mentioned, allowing for a shorter period where there is law and regulations so empowering it. It's important to mention that 540.5 applies to PIEs, public interest entities only, and it's also important to emphasize that forum of firm firms commit to comply with the code, and that's a factor that the working group had in mind as they were progressing this analysis of the questionnaires. And so I'll come back to that later. Next slide, please. So we received, as you've seen, 32 responses, and we had 14 respondents who commented raising issues. And this slide and the next slide are really the most important because they summarize the issues. And for those of you who have taken the trouble to read the issues paper, you will have seen that there is extracts from the responses setting out the points that have been raised. We have tried to group them in order to be able to analyze them or assess them in a sensible fashion. And we've done so under 3 headings. The first of which is where the relevant requirements in different jurisdictions are different from the code. The most notable of those is the position under EU regulation. So the points that were raised were that some jurisdictions have different time off, well, time on and time off periods, and some rely on mandatory firm rotation. What was asserted by various people was that the differences in requirements has the potential to cause confusion, increase complexity, and cost. And when I say different requirements, I mean different requirements in particular jurisdictions, because obviously it would be unrealistic to achieve global consistency. And there was concern expressed that as a result of the existence of alternative regimes, some jurisdictions would not adopt the 5-year cooling off provisions. You'll note that the vast majority, in fact, all but one of these comments is attributed to national standard setters and professional accountancy organizations, i.e. they are jurisdictionally focused on from the profession's representative bodies or standard setters. I just wanted to say a word about the EU, because that obviously is a large jurisdiction. It covers a lot of countries and a lot of significant countries and a lot of significant public interest entities. We received, the comments that we received that were focused on the EU came from a limited number of jurisdictions. I think I'm right in saying only 2 out of the 27, 26 jurisdictions. And the critical question that arises from the EU is whether the existence of the European regulation and the requirements or obligations imposed on member states, and please focus on that, the term member states, on the governments, precludes others adopting a more restrictive approach than is provided in the European regulation. The European regulation provides for a 3-year cooling off period. And the question arises as to whether or not the obligation on the member states constrains firms individually or indeed member organizations from having a different regime. And I will come back to the views that have been expressed on that issue in due course. So the first issue is the existence of different regimes in different jurisdictions. And indeed, it's fair to note that that's precisely why the jurisdictional provision was originally introduced, to allow time to assess the position and for people to consider how these issues sat together. Next slide, please. So the next issue that was raised came from a range of different sources and focused on the impact on smaller firms. And I think it's important here to mention that this wasn't just raised by the SME or SMP community, but was also raised by a number of the larger firms who have practices in small jurisdictions and were concerned about their ability to rotate, particularly in specialized industries. I think the point will be readily understood by members of the board, but so I don't need to, I think, to elaborate particularly. The concern was extrapolated to talk about market concentration and reduced competition. I'm not sure that's such a logical conclusion from the challenges. I think the challenges is focus more on audit quality if you don't have access to the people with the right qualifications for the job. And then there were a range of and other comments that were raised which are under 3 other comments, one of which is the one I've just mentioned about specialized industries and impact on audit quality. Second point, inevitably, was that people raised the issue of the revised definition of public interest entity, and would that mean that this had ramifications which were more complicated, impact of the pandemic, and a comment that given that it's only been the provision's only been effective for 3 years, really is too short a period in which to form a judgment on whether or not the jurisdictional provision should be extended or how it should be treated. So Jeff, next slide, please. So they also came up with a number of propositions. They advocated extension of the jurisdictional provision. They advocated conversion of the provision into a permanent, I don't think it's a requirement, but a permanent provision. They suggested adding a size exemption so that it would apply, the jurisdictional provision would continue in operation if the firm was small or the jurisdiction was small. They suggested that we should look at broadening the considerations, allowing more flexibility, so that if there were other safeguards, such as mandatory firm rotation at a particular level, that could be taken into account. And they suggested that we should reflect more on what the implications would be if a jurisdiction did not move to the 5-year cooling off period. So that is a summary of everything that we learned from our questionnaire. And basically that passed the ball back to the working group, and we went through and discussed at some length these different views. And I will now, if I may, set out our views and then ask for the board's comments on those views. So next slide, please. So the first discussion was about the situation if there are different jurisdictional requirements. And the analysis that we had in relation to the European Union highlighted the fact that, as I've already indicated, there's a distinction to be drawn between the relevance of the regulation to member states and the relevance of the regulation to professional accountancy organizations and firms within each jurisdiction. The argument for flexibility, i.e. the argument for saying that the EU regulation does not conflict with the jurisdictional provision, is that the language of Article 17.7, which is on the right-hand side of this page, refers to, in the last sentence of the first paragraph, they shall not participate again, that is the key audit partners, shall not participate again in the statutory audit of the audited entity before 3 years have elapsed. And on one reading of this particular provision, the word before does not establishes a minimum and does not constrain a longer period. And that is the view that has been expressed by a number of people. The contrary argument is that because there is an exemption in the second paragraph that allows for a shorter period than 7 years, which the absence of an equivalent provision or permission in relation to the cooling off period means that it's a mandatory period. I must tell you that putting a lawyer's hat on, I don't think that is appropriate, because the permission granted in the second paragraph is for a stricter position, whereas and that you can understand is something that member states needed to be given the right to do, but the provision for a longer period, which is more permissive on a closing off period, shouldn't be needed. The working group went through this in some detail. As I say, I've had discussions with a number of people about it. We have concluded that, given the fact that the regulation doesn't apply to, it doesn't directly apply without member state intervention to firms or to accountancy bodies, this is not a ground for arguing that the jurisdiction provision should be extended, and that is our conclusion on this. And therefore, we believe that the concerns about different jurisdictional requirements should not result in the jurisdictional provision being extended. Next slide, please. The argument about the combination of partner rotation and other measures such as mandatory firm rotation was given equivalent consideration. I think it's very important to bear in mind that partner rotation addresses the threats arising from familiarity and long association for those individual partners, whereas mandatory firm rotation is actually dealing with a different set of familiarity and long association threats, namely those that are institutional. And that difference has long been recognized. And whilst they obviously interconnect, we don't think that it is an argument to be able to say that because mandatory firm rotation exists, you should be allowed a longer period, a shorter period for cooling off. And we actually think the biggest issue relating to mandatory firm rotation is the coordination between the two regimes, so that you don't end up with incompatibility in terms of the length of time that individuals can be audit partners. Furthermore, this particular issue is going to be discussed, as I've already indicated, as part of phase 2. And therefore, again, we did not consider that this was a ground for on which to argue or recommend the extension of the jurisdictional provision. And that's our view thus far, subject obviously all of this to the board's views. On partner availability in small firms, yes, that's indeed is something that is regularly raised in relation to this area. It's raised whenever there's a question mark about the length of time that a firm should or should not be continuing as auditor. And our suggestion, if there are jurisdictions which are problematic, is to look at getting an exemption from the local independent regulatory body, which to vary the period on which you could be the audit partner. As far as other points are concerned, yes, there are challenges, but there are 2 points in relation to that. The first is that those challenges have existed existed at the time when we went through the long association project itself, and they were considered, and the conclusions were nevertheless reached that we should proceed with a 5-year cooling off period. And we believe that most of those challenges have been managed, and it's notable that that's been the position over the past period and going forward, and will be going forward. So the upshot of all of this is that we, having considered all of the arguments that have been put forward, next slide please, believe that the correct course is not to extend the jurisdictional provision. We believe that things like mandatory firm rotation are appropriately being considered in phase 2, and I will be asking for your views on any other matters that we should consider before we finalize a report to the board taking account of your comments today. Stavros, at this particular stage, I think what would be appropriate is just to ask the board for views on the first question, which is, do you agree with the recommendation or the current view that we should not extend the jurisdictional provision for the reasons I've articulated? And if we take that first, then I'll pick up the second 2 questions afterwards. And I'd welcome views.
Thank you very much, Richard. Please focus on the first question. If there is agreement that the provision should not be extended, and I invite comments from the board, please.
The floor is open. Comments, questions? Let's kick off with Kim.
Thanks, Ken. Thanks, Richard. Hi. I guess I wanted to get your thoughts on primarily the EU discussion and the difference between the 3 and the 5. Does the working group have any thoughts about whether or not this will hinder adoption going forward? I understand about the form of firms and that we are committed to complying with the code, but I'm just curious about the reaction about the 3 and 5. I remember back when these discussions took place, and originally, if I recall correctly, there was a leaning towards a 3, and then due to some commentary and some discussions, the 5-year was ultimately agreed upon for the standard with the transitional jurisdictional aspect to it. So, but that's just a little concerning to me is the adoption aspect, and whether or not that it could be problematic that we would see partial adoption or this being carved out. So I'm curious what your thoughts are just based on all the information that you've obtained.
Richard, if you don't mind, let's taking Lisbeth also. Lisbeth, you have the phone.
Yeah, thank you. Yeah, my concerns are similar to what Kim was just saying about adoption, and it's not just adoption; it's actually application issues that we might be creating, which might result into situations where a PA will not be able to comply with the code. Let me try to explain that a little bit further. First of all, with regards to the European situation, I fully understand your legalistic way of reading the reform or the audit reform. I have had discussions with my TA on this as well, and we both agreed, yeah, this is how you could read the law. But when you think about practical applications, and I'm now going to refer to France, as we have discussed this as well as part of the PI project. Actually, in France, it's not as simple as saying, oh, CNCC will implement a longer cooling off period in the standards, because it is what the legislator has put in law that would eventually be applicable. So the CNCC cannot simply overrule the 3 years that are in the French law. And it's a similar situation in Belgium. So you're going to be creating issues for all these PAs, perhaps not forum of forum members, but that have good intentions and want to apply with the code. They won't do it. It's my first reaction. Secondly, the argument I've read throughout the presentation on, well, these PI entities, they're audited mostly by forum of firms members. I think that's a very weak argument. It's not because you're a forum of firm member that you will be able to apply this in practice. So we're basically potentially creating a situation where even a member of the forum of firms will be forced to not abide by the code because of some very good reasons by removing this exception. We as a large firm have had to use the exemption because of the issues around lacking specific expertise. And so that would mean that we need to give up our audit, basically, and that then could lead to market concentration issues, but also issues around audit quality, because you might well have had a very technical partner who was doing a great audit, and because of the fact that they had to roll off after 5 years, or they have to be away for 5 years, sorry, you will decide as a firm to basically appoint someone with less technical knowledge, and that would then harm the audit quality on for the particular audit client. And that to me is a public interest issue. So I find it a little bit too easy to, based on these comments, to all ignore them, because I do think that these respondents have some very, very valid points they make, because we're going to create issues. Am I saying that we need to make this a permanent exemption? No, absolutely not. But I think we need to look at this in combination with phase 2, what comes out of there, because there might be other means to deal with the issue of the familiarity threat. And so my recommendation is actually to extend the exemption until we have been able to look into part 2 of the project, because it might be resolved automatically by part 2.
Okay. Back to Richard.
Right. Well, Kim, let me go back and start with Kim's comment. I think the views that have been expressed in the responses we received did not suggest that there would be problems with adoption, with the exception of 2 jurisdictions who took the view that was because they took the view that they would not be allowed, it would be wrong, illegal, not lawfully permitted for them to go to a 5-year cooling off period. I have to say that in the respect of one of them, having spoken to the person involved in preparing the response, he acknowledged that it was a tight, it was difficult to determine between the merits of the 2 legal arguments, and they came down in favor of the one that that supported retention of the jurisdiction provision. But very fairly, he acknowledged the strength of the alternative argument. Elizabeth, your concerns, I think you fairly described them as practical application issues. And of course, there are always practical application issues in the adoption of the code, and countries like France, which has a different regime for this type of area, has in the past raised issues and will no doubt continue to do so from a consistency across the globe perspective. I must say, the argument that you make about specific expertise, I find a little difficult to follow personally, because if you've got a problem over specific expertise, not having a sufficient specific expertise for 5 years, with a 5-year cooling off period, I'm not sure that a 3-year cooling off period necessarily makes that any easier to manage. So I don't completely follow the practical implications of that. The other point to make about the looking at it extending it and looking at this issue again in combination with phase 2 is, and let's be realistic about it, is that's effectively a 4 to 5 year or more extension period, because the phase 2 doesn't start till 2023. You're then looking at a period of no less, I'm sure, not less than 2 years if you're also considering mandatory firm rotation for consideration of the issue. And then you've got the date when it becomes effective. So you're looking at a 5+ year extension of the jurisdiction provision. And as you're aware from prior discussions, that isn't a view that's going to be readily accepted in certain quarters. And at the moment, and I hope believe I reflect the working group's view, that isn't an approach that we believe is warranted by the arguments that we've heard so far. But obviously, we're open to hearing and understanding. We'll reflect on, Elizabeth, views expressed by you and others on the board between now and December. Please don't assume we will not.
Thank you, Richard. Other board members, please. While waiting for those, Stavros, would you like to go first, or
no.
Ask Rich to go first.
Put in, after other members have expressed themselves.
Okay.
So,
okay, Rich, you have the floor.
Thank you. I am perhaps, maybe I'm just not that versed on it, but I'm not following this argument that it would be illegal. If a country has a law that says you must stay off for at least for a 3-year period, extending it beyond that in the code isn't failing to comply with that law, and it implies that you would the argument seems to be implied that people would immediately put somebody back on, and that doesn't make a lot of sense to me, especially given that in the 3 years that they are off, they have had to replace them with someone who is eligible to serve up to 7 years. So I don't see a basis for extending the jurisdictional exception. It was put in the code in the beginning with a definite expiration date, and people have been adequately warned that it's coming and will expire. And it seems like the further extension is not really, in my mind, in the interest of the code and the public interest.
Rich, Caroline, you're next.
Thanks, Ken. Thanks, Richard, and for the presentation. In Asia Pacific, I'm aware of jurisdictions where on one engagement you could potentially have 3 partners involved. So there's 2 partners, a signing partner, as well as 2 partners who have to sign for the audit report. And on top of that, there's the engagement quality reviewer. So if you have 30 partners in that partnership, for example, with rotation, essentially it brings that down to 10 partners, because each time you've got 3 that will need to rotate off. So I do appreciate the challenges that might apply in certain jurisdictions, and maybe Elizabeth has a point in saying that we should look at what comes out of phase 2 before making a decision on the jurisdictional provisions. And I think we also have to bear in mind that in terms of the PI project, the expansion of the definition of entities that will fall within what is defined as a PI would also have an added impact as well. Thank you.
Okay, please have other board members as well. Please, Wayne. Stavros, I'll turn to you first.
Thank you. I think that we should be careful not to change what is in our SWP. In our SWP, we had agreed that this phase 1 would be considered now just before the jurisdictional clause is about to expire, and that in phase 2 we're going to look at the broader issues about how effective and what are the impacts of the broader loan association provision. That means to me that we have 2 tasks. One is to judge specifically the jurisdictional provision now, and another is to judge the overall effectiveness and effect of the provision, which will probably reopen some of this discussion, even if we don't now agree with the extension of the jurisdictional provision. So I think we should keep those separate and make a decision now as to what we'll do with the jurisdictional provision only, and not reopen all the arguments, because I hear a lot of resourcing arguments that have been discussed at length during the discussion of this standard. My view is that the jurisdictional provision was a clear exception, and it was, to my mind, supposed to be a signaling that at the end of the time of this jurisdictional provision, firms and organizations should have taken steps to be able to face the stricter regime instead of imposing it right away. If we now reverse this signal and say, well, you don't have to do it until maybe another 5 years, I think that you weaken the incentive that the code gives to firms to be able to, over time, to adjust the resources and increase their resources so that they could comply with the provision. So I think we should see it in a dynamic way. And this was a signal saying, look, after the provision is out, you'll have to adjust to that if you're adopting the code. And there was adequate time for firms to adjust to this. So in my view, it does not make sense to give a signal about what is a necessary adjustment in order to be able to comply to the code, and then reverse this signal and in effect give another signal that says, don't worry, it will never happen. I think it will, if we renew the jurisdictional provision now, it will cancel out a lot of the effectiveness of the standard that we have. So I'm certainly in agreement with the proposition that we let it lapse, as the working group is suggesting.
IESBA, you want to comment on this?
Yeah, I agree fully with what Stavros was just saying on the reason why we included that exemption in there. It was with the, if I remember correctly, it was with the intention to give standard setters time to adjust their cooling off period to the 5 years as in the code. But this is a question to the task force or your task force or your working group, as to whether we have any insight into, well, how many jurisdictions around the world actually managed to adjust their codes to reflect what's in in the current extent code with regards to 5 years, and whether apart from this survey, we might have some further insights from those jurisdictions that decided not to move to the 5 years, what the reason is to decide, well, what is the appropriate way forward. And that might potentially give you some very good insights for your second part of the exercise. So I'm curious to find out, like, well, how many jurisdictions actually took action upon our requests, well, upon our exemption, saying, here, we allow you for a couple more years to use the 3 years, or the 2 years, sorry, no, 3 years. However, we expect from you that you adjust it to 5 years. I would like to understand how many actually succeeded there.
Can I?
Yes, please, Richard.
Come back. Elizabeth, I'd have to count it up, but the very few had taken advantage of the jurisdiction provision on a national standard setter level. The majority had not. There were some that had, for example, and this is relevant to Stavros's comment. You may recall that one of the jurisdictions that was most exercised, I should say 2 jurisdictions that were most exercised by the 5-year cooling off period was Australasia. And that, if you remember, was because they were in the process of actually implementing something that they'd already had out for exposure and so forth, and they wanted time to make the transition. Now, we've had discussions with Australia, representatives in Australia, including with Fiona Campbell, and the view there is, although that the professional organisations would prefer to stay with their current regime, the view is that they would not have a difficulty in practice in going to the 5-year, removing the jurisdictional exemption. We can certainly let you know how many answered the question by saying that they had applied the jurisdictional provision, but I don't have that off the top of my head. And bearing in mind that we had only a limited number of, obviously only a limited number of jurisdictions responded, it's not necessarily representative. But I wanted just to come back to the other comments that were made. Rich, I noted your comments, thank you, but I also thought that your comment about the fact that a new appointee will have been appointed for a period of time that is not likely to be 3 years is relevant to the practical issues, but we'll obviously think further about that. Caroline, your point about three-partner position, i.e. dual signing combined with the EQCR, is one that was made in submissions in one of the responses or two of the responses we received. I absolutely recognize that complicates the situation, and I would just emphasize the need, if there are jurisdictions with small firms that have that situation, our recommendation that they should actually look for an exemption if it's needed to make sure that that situation can be managed. I would not, I think the working group would not, I think, take the view that those jurisdictions alone and that argument alone was one that warranted the extension of the jurisdictional provision globally. And that's the distinction that I seek to draw by referring to local arrangements approved by a local regulator. Stavros, your point, obviously, I've completely recognized the force of the point that we gave a message. We wanted people to move to 5 years. We still want them to move to 5 years. There's no suggestion we don't. And I think that your comments in that regard tie in with my comment that I'd be worried if this got deferred to phase 2, given the length of time before that would mean that anything came to pass, because you'd be looking at effectively the better part of probably another 5 or 6 years. And Elizabeth, just to come back to yours, we can certainly make sure that in December we give you as full an answer to the point about jurisdictions as we have available, and we can continue to use outreach in the intervening period, and obviously things like the National Standards Setters meeting and so forth are opportunities to check that we've got as much information as we can get. So Ken, unless any board member wants to raise any other issues, I think it's implicit.
Pardon me, I see that Ken wants to make a comment also.
Yeah. Well, I don't see any other board members who would like to weigh in at this point, but I did have a couple of comments, Mr. Chairman, if I may. One is to really go back to one of the points you raised, which is, the rationale for the board to in the first place establish the jurisdictional provision, and that was precisely in recognition of the significant impact this change in the cooling off requirement in the code would have in practice, and therefore the importance of allowing jurisdictions, national standard setters, and firms to prepare and adjust their resources and be in a position to really move to the 5-year cooling off period at the expiry of jurisdiction provision. So that's an important objective and an important rationale not to lose sight of. There was a reason why the board went ahead with the jurisdictional provision. The second point I want to raise is feedback staff has received from, in particular, the regulator in Australia, and that potentially could be a representative of some potential reaction the regulatory community might have if the board were to extend the jurisdictional provision. And the feedback was essentially really just on the 5-year allowance itself within the jurisdictional provision. And really there was a sense of consternation any question raised as to why the board had in fact even allowed such a lengthy lead time before the 5-year cooling off period would come into effect. So already there was, and I would imagine there remains concern that there are still 2 years to go before the expiry of the jurisdiction provision. And there were expectations already within the regulatory community, as I say, that the 5-year cooling period would become effective at the earliest opportunity. So I just caution the board to really bear that in mind. If there were any sense that the board would extend the period, to just have regard to how that might be perceived and received on the other side.
Thank you, Ken.
Back to you, Richard.
Well, I think the flavor I'm getting is that, yes, there are some aspects of this that people would like us to look further at, which Elizabeth has raised. I think that I've not heard general board disagreement with the proposal that we should allow the jurisdiction provision to lapse. And I think I would suggest that against that backcloth, the answer to question 2 is self-evident, that namely issues like mandatory firm and so forth should only be addressed under phase 2. I'm not hearing anything that suggests that that would not be the appropriate course, but I will, if I may, Stavros, just pause there to make sure that if anybody wants to say anything, they can, before raising a couple of issues under the third heading.
So we're opening the second question now, or both, 2 and 3?
No, just 2. Just let's clear that off, Stavros, because I'm not hearing any suggestions that we should do anything other than leave mandatory firm rotation to the phase 2.
Well, it's sort of obvious, but yes, put the question. Any comment on that, please?
Okay, the floor is open. Any board member who would think otherwise with regard to question 2?
And to be clear, the reason for asking the question is that some people advocated that we should row in mandatory firm rotation at this stage when considering the jurisdictional provision. And we don't think that's appropriate. It deals with other issues, and therefore it should stay with phase 2.
I don't see any board
okay.
raised, Richard. Yeah.
So I then just want to touch on the position between now and December. I've already acknowledged the Elizabeth's request for more information, such as we can, about how jurisdictions have actually acted, and we can try and produce that information in a intelligible and succinct form. We have a CAG meeting in September when we will obviously get their views and obviously report to them the points that have been raised today. And then we're due to produce a report for the board's consideration in December. And unless something unexpected happens, I think it's fair to say it's going to recommend, it's likely to recommend that we allow the provision to lapse in its natural course in December 2023. And then there will be a need to publish that decision. And Ken, I'm really looking at you. I'm assuming that we would have a press announcement, if that's the way the board goes, a press announcement which would also cross-refer to the working group's report and its adoption by the board, or some such message, so that those who want to know what happened can actually understand the reasons for the decision.
Yes, that's correct, Richard. And we can work with the working group and the board in terms of how we formulate the announcement or the publication of the board's decision. I just wanted to also remind the board, or let the board know, that there will be a session with the national standard setters in October, Richard. It's not on the slide here, but we've scheduled that.
I think it would be useful, least of all, not least because of Lisbeth's question, to have the opportunity just to explore that, and I would welcome that if that's possible, Ken.
Yes, we have that on the preliminary agenda.
Yes.
So
Richard, I have a
please.
I just have a query. The standard as it stands itself says that the provision is going to lapse, right? So
Correct.
we're not changing anything.
Correct.
There's not a decision of change of anything. There's
No,
there's going to be a board view, if you will, that the standard stands as is and the provision lapses, right?
That's correct. That's correct. But nevertheless, given that we have an SWP that said we would look at it, and we've publicized the fact there's a working group, we still need to publish the outcome of that review. And that's the focus that's the focus of the press announcement and the report.
Okay. All I'm concerned about is that we don't end up with a situation where there is a misperception that we've made a decision, whereas we haven't really made a decision. We simply let things stand. That's all. No?
Understood. Okay. Does anybody want to raise any points in relation to the way forward as I've described it?
The floor is open. You see no hands raised, Richard?
No, so we can go ahead. By the way, I meant to mention that and to recommend to people, if you haven't seen it already, that there is this IFIAR report, which includes a survey of their membership about various areas of independence and audit quality and what have you. And there is a very interesting part on which goes to indirectly to what Kim was asking and Lisbeth about the adoption and the impact of the IESBA Long Association standard among various jurisdictions of IFIAR members. So it might be an interesting source for future discussions, but it's also very interesting to read.
Thank you, Stavros. So, Stavros, I think I haven't got anything further to add, unless you want to ask Galen and Robert for any comments.
I want to ask both for any comments, Galen and then Robert, before I close the session. So, Galen. We will be discussing this at the CAG, I take it.
Yes.
Yes, we will.
Yes.
Yeah, thank you, Stavros. I think there's some good arguments that have been raised, but I really kind of go back to what Rich was saying earlier on this rotation matter, that it's hard for me to understand how somebody would step in after into the first rotation that's required with during the 3-year off period, and that individual not being able to continue for an additional period that would create a problem. But this is something that has arisen outside of my personal jurisdiction. I know the hardships. I'm very familiar with the difficulties with rotation, and I think Stavros has raised an excellent point. I mean, if you make an exception, then will there be an exception following that? And I hate to see it as a precedence, but I'll look forward to discussing this next year with the CAG. Thank you.
Thank you, Galen. And Robert.
Thank you, Chair. No comment on this other than just to say that I'm very comfortable with the direction of travel. Thank you.
Thank you very much. Thank you very much, Robert. So I believe that we can now close the discussion and look forward to a final proposal by the working group. and also the additional information that some members, as Lisbeth, have asked for, which would be valuable for the final outcome. So thank you very much. Thank you, Richard. Thank the working group and the staff, and thank the board for your views. I'm going to close off the session today. This was a very useful and very rich day, as the others have been, but we're not finished just yet. We still have a meeting on the 27th, in which we are going to look at the tax working group will be coming back on that day, but the main topic of that day will be engagement team and group audit, another area where we're moving towards finalizing an exposure draft. So thank you all very much. I hope you can relax after this rather intensive experience of this week. Nevertheless, I think that we managed to get a lot of very valuable input and make progress. Thank you. Go well and see you on the 27th. Goodbye.
Bye, Ron.
Bye.
Thank you.
Goodbye, everyone. Be well.